Hey guys, it's Anthony Bandiero here with Blue to Go Law Enforcement Training, and today I'm bringing another roadside chat from studio. Today's question is, what is a cat out of the bag search? So this ties in with another video that I made about private searches. Just to remind you, a private search is not a Fourth Amendment search. It does not have to be reasonable. We don't care if it would offend the Fourth Amendment. If you did it, if the police are not involved in it and they didn't encourage it, it's not a Fourth Amendment search, period. You can use the evidence. Now let's talk about this related issue, which is, what if somebody sees something, right, from a private area, like say, for example, they bring you a backpack from a roommate's bedroom, right? And they say, hey, look, there's drugs in here. There is a doctrine out there called cat out of the bag search, and it allows officers to conduct the same private search that the private person did without offending the Fourth Amendment. So let's kind of dive into this and explain what's going on here. So let's walk through this. So imagine a roommate suspects that their fellow occupant is selling drugs. One day they go into the occupant's bedroom, snoop around and open up drawers and look in closets and look into a backpack, and lo and behold, they find 2 ounces of methamphetamine. Shocked and pissed off because their roommate they confirm what they are doing, they bring the backpack to you at the police station. The legal question is, what can you do with that backpack? And the answer is the exact same thing the private person did before they entered the police station. That means that if an officer unzipped the backpack and looked inside and saw those 2 ounces of methamphetamine, that officer could seize that meth as plain view. And here's why. The cat is out of the bag. In other words, the private person, the actual defendant in this case, has lost his reasonable expectation of privacy as to what is in the backpack. Think about it. Is it reasonable for a person to have this private search conducted by their roommate? We're talking about the defendant's point of view, and their roommate found the drugs and then brings it to the police station, and that roommate says, hey, look, I know it's in here. There's this substance that looks just like narcotics, is the way it's packaged, and maybe they have personal experience with it. But my point is, there is probable cause that there's evidence in this bag. It's not reasonable anymore that the defendant has privacy as to those contents. I mean, it just doesn't make any sense. As a Supreme Court said in a case called Jacobson, the cat is out of the bag. We know what's in it. Therefore, the police can do the exact same search. But I want to follow up with a couple points here, because this is a very, very powerful doctrine that has saved a lot of searches in the past. The first thing is, remember, you can only do the exact same search the private person did. So let me give you an example in this backpack. If the roommate, right, not the defendant, but the roommate did not search a pouch in the backpack, can the police then search that pouch without a warrant? No. No, they cannot, because the cat is not out of the bag as to the contents of that pouch. Now, we certainly have probable cause to search the entire backpack now, but that means you have to go get a warrant. Remember, PC alone is never all you need for a search. You have to have something else. It's PC plus. It's PC plus exigency. It's PC plus a motor vehicle. Here, it's PC plus the cat is out of the bag. In other words, the private person already did the search. So if an officer opened up that pouch and found 2 more ounces of heroin, that evidence will be suppressed. It also means that you cannot really go above and beyond the search that was already conducted. In other words, be careful about doing forensic analysis on things and sending things to the lab and so forth, because that is not what the private person did. You really should be getting a warrant to do a search that's above and beyond what the private person did. The second issue is you have to have lawful access to the item. what I told you in this case is that the roommate brought the defendant's backpack to the police station. It would not be allowed for the roommate to call police, tell the officer, hey, the backpack in the defendant's room has contraband in it. The officer could not then enter the room to go grab the backpack out, because even though the cat is out of the bag as to what's the contents of the backpack, it's still shielded by another layer of protection, which is his room. So just remember, that is also what's going on here. Let me give you a case example that illustrates this. A person, a victim, was invited back to an apartment with some party goers. Well, their intention was actually to rob this guy. So they get him back to the apartment, they steal all his stuff, and they throw him out. He calls police, the police arrive there, but by the time the cops come back, these guys are gone. And they tried to, they knocked on the door, nobody answered. Then the victim, back up. The victim also told police that there was contraband in the room, like drugs and so forth. So the cat is out of the bag as to what's inside the apartment. Then the victim opened the door and was like, hey, I'm going to show you where everything is. The police officer then entered the apartment, looked around, and found contraband in plain view. Are we good? No, we're not. Because even though the cat is out of the bag as to maybe it's inside that apartment, and certainly a warrant could have been received, the victim had no authority to re-enter that apartment to bring in police. I mean, that's just not how it works. I mean, he was lawfully present at one time, but he's no longer lawfully present now because there is no exigency. He has no right to that apartment. It's not his. And essentially, he's trespassing. So just remember that. That's a cat out of the bag search. I find these searches fascinating, and they have saved officers in some very serious cases. Just to give you an example, some officers have searched digital devices because the person has said, hey, my boyfriend has child porn on his phone. And then he brought the phone to police. And then the officers searched the phone and found the same child porn that the girlfriend found, while she was messing with the boyfriend's phone. And courts have upheld that as a cat out of the bag search. But that's a brow type of sweat, issue, because as an attorney, I do not train police officers to search digital devices under this theory, even though it can be done. Courts really want you to get that warrant for all digital devices. So the fallback position is a cat out of the bag search if the police have lawful access, but that is really not best practice. I hope it helps. Keep your questions coming. Until next time, stay safe.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.